Okay, so for those of you who are still here, that's great. Thank you for staying with us. And I will do a quick introduction and we'll jump into the presentation. A lot of you may know me, but if you don't, my name is Heather Staggs and I am the president of Star Momentum Training and Consulting. We are a training and consulting company based in Colorado. And we do a lot of work in South Dakota, and actually South Dakota is one of my most favorite places to visit. So, and I know I've said that to you a lot before, but a little bit about my background. I started in property management. I was a leasing consultant and then worked my way up through the ranks and actually ran a property management company for a short period of time. I was the director of property management. And then I decided I wanted to go over to the regulatory side, and I worked for the Colorado Housing and Finance Authority. And for a short period of time, I was actually out visiting properties and doing management reviews. And then I also worked at the Denver HUD office for a short period of time as a project manager, and actually had South Dakota in my portfolio. That was my main state that I worked with. And then I went back to CHAPA and ran the contract administration department, so the project-based Section 8, and also oversaw the housing credit program. And then about 4 years ago started a training and consulting company so that we could provide quality training and consulting to affordable housing properties and owners. So let's just jump in a few housekeeping items. As Vana had mentioned, I will be happy to take calls and emails tomorrow after the presentation, so that if you do have questions and we're unable to get to them due to timing constraints today, I will make myself available. And as Vana said, we'll also do a Q&A and have it posted to the SDHDA website. You may hear some things today, and especially because we're talking about legal items, especially with fair housing, please don't implement anything that you hear today without talking to your supervisor or anyone who might be a decision maker. You can ask questions as we go. I do have the chat bar up, so if I do see a question pop up and I can take it, I will be happy to do so. The one thing that I like to tell everyone who takes a fair housing class is that it's extremely important to take this fair housing class or some type of fair housing class annually, simply because we're seeing a lot of changes as time goes on. I'm going to talk to you about some recent case law in just a little bit, and you'll see that there have been some major changes. Because this is a legal issue, because we're talking about the law, we're talking about the Fair Housing Act, you may seek good legal advice, especially if you receive a complaint or you have to file an answer with either HUD or a fair housing agency. And then if I do talk about any type of products today, just please know that we're not sponsored by anyone and we do not endorse any particular products. So what I'm going to do is I'm going to give you just a brief history, especially for those of you who are new to fair housing or maybe new to your property and have not had a full fair housing training yet. At least this will give you a little bit of a background. So the Fair Housing Act was actually an extension of the Civil Rights Act of 1964, but President Lyndon B. Johnson signed into law the Fair Housing Act on April 11th, 1968. So we actually celebrate Fair Housing Month in April of every year. And this particular past April was the 47th anniversary of the Fair Housing Act. And you know, we're coming up on the 50th anniversary. So I think that we will see a lot more added to the Fair Housing Act in the way of amendments. I believe that there will be additional protected classes that we will see, and I predict that this will probably happen before the 50th anniversary. Please know that if you are dealing with any type of property management, that fair housing is not an option, it's law, and you have to follow it. And unfortunately, or fortunately, that if there is a complaint, or if HUD or an administrative law judge or a fair housing agency finds fault in something that happens at your property, you could be potentially liable personally for any kind of fair housing complaint. And I will go through some of those with you in just a little bit. So some additional legislative history. When the law was signed into law in 1968, what it did is it made transactions subject to the civil law, and it holds property managers, owners, and landlords responsible for discrimination. So you have to make sure that you are providing housing to everyone on an equal basis, that you're advertising on an equal basis. When this law was enacted, there were only a few protected classes at the time. So that was race, color, national origin, and religion. As the time has gone on, and as I said, I believe we'll probably have additional protected classes added, but as time went on, we did have additional protected classes added. In 1973, Section 504 of the Rehabilitation Act was enacted, and what that did for those of us in property management is it provided guidance and laws around helping persons with disabilities. How it specifically relates to us in property management is that if you have a property that receives federal funding, you have to provide the opportunity for reasonable accommodation for persons with disabilities. And we'll talk in more detail about that in just a few minutes. So again, the Section 504 of the Rehabilitation Act says that you have to provide housing. You cannot discriminate based on disability. It also puts some parameters around the type of units that you have to offer, and what the law says is that 5% of your units must be acceptable, or accessible, I should say, for those who have mobility impairments, and then 2% of the housing needs to be accessible for those who either have visual or hearing impairments. In 1974, the Housing and Community Development Act was made part of the Fair Housing Act, and what this did is it added gender and sex to the protected classes that we serve. And where we're seeing a lot of case law around this today has to do with violence against women and gender identity, and we'll talk about that in detail as well today. Then in 1988, the largest amendment was made to the Fair Housing Act, and that's called the Amendments Act. And again, it was enacted in 1988, and it added several things to the act. It added familial status as a protected class, and it also added disabled persons as a protected class, and gave us a definition of a disabled person under the law. So that definition was made part of the Fair Housing Act, and it could be different for different types of federal law, but as far as the Federal Fair Housing Act goes, it was defined in 1988. Some other things that happened were that anything that was built after 1998, and especially after 1991, certain things have to be put into place as far as new construction for housing, and if you're housing individuals with disabilities, whether it be physical or mental, there are certain parameters that you have to stay within. One of the things that may affect your property is this part of the law that was added. President Clinton added it. It's the Housing for Older Persons Amendment Act. And what this did is it said that you can have certain housing set aside specifically for the elderly, and you do not have to follow the familial status part of the law. That's the only exemption. All of the other requirements are still in place. But it did give some protection to owners, saying that you can set up housing specifically for the elderly. Now, if you have any programs at your property that are governed by the HUD handbook, this does not apply to you. So if you have Section 8, you may have a 202 PRAC or any kind of elderly housing, those programs are not covered under this section of the law. So just a quick, brief overview of the 7 protected classes that we're going to be speaking about today. The first one is race, and you'll see a little picture next to the words. Some of you may be visual learners, I know I am, and so this may help you remember some of the protected classes that we're going to go through. And I will also give you all of the definitions of these protected classes as well. So we have race and color, national origin, religion, sex and gender, disability, and familial status. So let's jump into the definitions of the 7 protected classes. The first being race. This is often confused with color or national origin, but race is a group of people united or classified together based on common history or their nationality or a specific geographic region that they originate from. And this can also be defined as persons who have the same inheritable physical characteristics. They have the same skin pigmentation, the same hair texture, same facial features, that type of thing. So again, this is very similar to color, but is different than color in that color is just that. It's the color of someone's skin. So for example, you could have a African-American manager and African-American applicant, and the African-American manager could be a dark-skinned African-American and the applicant could be a light-skinned African-American. Where they both have the same race, their color is different, and so there could be discrimination based on color if the manager happened to discriminate against the light-skinned African-American and said, you know, we don't want anyone but dark-skinned African-Americans to live here. That could be considered discrimination based on color. National origin is the birthplace or where someone comes from or where their ancestors come from. So it could be that someone is here, they were born in the United States, but maybe their direct ancestors, their parents or their grandparents, come from a different part of the world. They would be covered under national origin. And one thing I'd like to say too, just back to color, everyone is covered under color. So that includes Caucasians, everyone, Asian, African American. So it doesn't exclude any type of color of skin. So everyone is covered under race and color and religion. Especially with religion, it could be that you have a organized traditional religion or that you do not have any religious beliefs. So just because you do not, if you don't practice any religion, you are still covered under the law. There's two parts to religion, and what this is that both the person who's supplying or living at the property is covered under religion, and then anyone who is related to that person, whether it be through marriage or otherwise associated with the individual that has a particular religion, they are also covered. So if, for example, I wanted to move into your property and let's say I was Jewish and my husband was Catholic, and you did not want any Catholics living at the property, I would be protected, obviously, because my husband's religion, and vice versa. If you did not want anyone that was Jewish living at your property, then my husband would be covered. So those are just some things to keep in mind when it comes to religion.
Heather?
Yes.
It just came to my attention that I think I was presenting the first slide all of this time. Can you go ahead and show your screen?
Yes. Let's see.
I'm really sorry, folks. I didn't realize. Actually, Tasha pointed it out a couple minutes ago, and we thought, oh, maybe it's just a fluke. But
okay, so let me see. It says it's loading.
Yep. And there we have sex, gender, slide 19.
Okay, great. So I'm going to go back just quickly and show you. There hasn't really been anything major that you've missed, but the one thing that I'm going to show is just the 7 protected classes. Can you see that on the screen?
Yeah, well,
okay.
Just the title is on there. There's no picture or anything right now. Is there? Should there be a? I'm really sorry about that, folks, but the slides are out on the webpage, so you can get them all later, or hopefully you have them in front of you. Thanks for pointing that out to me. I really appreciate it. And
Absolutely. Okay, so now can you see that race came up?
No.
So my animation might not be working.
I'm thinking it's not.
Okay. Well, hopefully, let's see.
Return to presenter view.
It's showing that I'm presenting at the top of my screen. It says I'm on slide 12 of 97.
Yes, it does show that. And all I'm seeing is the picture across the top and the seven federal fair housing protected classes, but there's nothing else on that slide. Do you need
Okay.
maybe?
Are you able to see the people on the screen?
You know what? Everybody else says they can see it, so I'm saying open.
Okay, perfect. So I see that a few people have said that they can see it. Great. So since you can see it, I'm actually going to go back real quick, and so you can see here that there are 7 protected classes. So again, race, color, national origin, religion, sex and gender, disability, and familial status. So we are going to talk about each one of these individually, in addition to the descriptions I just gave you. But I'm going to go into more detail about disability and familial status here in just a second. So we went through race, we went through color, national origin, and religion. Sex and gender. So again, we're starting to see a lot of case law around violence against women and the Violence Against Women Act and how it relates to fair housing. So at the end, I'm going to, if we have time, I'm going to go through some of the most current case law because it's really affecting how you operate and the management decisions you make related to victims of domestic violence and also how it relates to the Fair Housing Act, because not only are you following the Violence Against Women Act, which is law, you're also having to apply that to fair housing. So it gets to be kind of cumbersome and a little bit difficult for those of you who are on site. The definition of sex or gender as it relates to the Fair Housing Act is simply that if you discriminate against a man because he is a man or a woman because she is a woman. You'll see as we go on through the presentation, there's been additional groups that have been added to this particular category of sex and gender, which would be lesbian, gay, bisexual, and transgender individuals. So especially if you have a Section 8 or a HUD program at your property, you have additional rules that you need to follow. With familial status, there are several areas of familial status that you need to know about. The first being that it refers to families with children under the age of 18. It doesn't matter how many children are in the household, and it does not matter if they are actually part of the household due to a custody agreement or if they are grandchildren. Any children in the household that are under the age of 18 actually fall under this law. So it could be someone that does have legal custody or does not have legal custody. It could be that the children are just there with the parents' permission. It also covers women who are pregnant. So this is where the rule changed that we can no longer, those of you who have been in the business a long time, you may remember that at one point we would ask people who were pregnant to provide us proof, whether it be a doctor's note or hopefully we weren't having them, giving them an EPT stick and asking them to bring us back the results. But at one point in time, we were having people having to prove that they were pregnant. The law says now all that is required is that it is a self-certification. If someone comes in and says that they're pregnant, they are pregnant. And when I say when someone comes in, it could be anyone. If a male comes in and says that they're pregnant, and you need to just take it at face value, have them do a self-certification, and it is what it is. So just be very careful with anything related to individuals who may be pregnant. The other exemption to this familial status rule is that Older Persons Act law that was put into place in 1995. And again, just to review, that covers housing that is specifically for the elderly. It does not cover HUD housing. So it does not cover 202, 811s, PRACs, any HUD insured loans. Anything that is governed by the HUD handbook does not fall under this. So if you do have an elderly property and it is a HUD related elderly property, please know that these things I'm going to talk to you about right now do not cover your property. So the first exemption to the familial status law is for those persons who are elderly. And what the law says is that it is either a state or federal housing program that the secretary determines that the property is designated or operated under. And when I say secretary, this means the secretary of HUD. The second one is housing that's provided for those individuals who are 55 and older, and at least one person at the property needs to be 55, and at least 80% of the property must be set aside for those individuals who are at least 55 and older. So what this means is that you could have someone come and apply. So maybe you have let's say you have a 58-year-old and this 58-year-old's wife is 45. They can move into the property because at least one person is over the age of 55, and you have set aside at least 80% of your property for those individuals who are 55 and older. The last exemption to the familial status law would be those properties that are set up and specifically for the elderly, and those individuals are 62 and older. What this means is that every single solitary person that occupies the unit has to be 62 and older. So the example I just gave you, where you have a gentleman who's 50, or let's say he's 63, a gentleman who's 63 and he has a wife who's 45, they're unable to move into your property because the wife is under the age of 62. So again, this is an exemption to the familial status law, and you do have to follow all other fair housing laws. It's just the familial status. So how this affects those of you who have these types of properties is that if it is grandparents and they're wanting their children to move in, they don't fall under this. Kim, I got your question about, does this relate to RD? I don't know the answer to that question, and I'm happy to find out. If someone else does know, feel free to speak up, but I will research that. I believe that what the law says is any HUD related. So I will do some research on RD and get that information back to you. You can either email me or I'll send it to Vana and she can put it on the frequently asked questions and answers. But that's a great question. I'm not an RD expert, unfortunately, but thank you for your great question. Okay, so persons with disabilities, I'm going to give you all of the definitions and go through this with you and go through the definitions as well as how this applies to your properties, because there's several different areas, as you've just learned, of the law that deal with persons with disabilities. So this is the actual verbiage of the law, and it says who is considered disabled. So it's anyone with a physical or mental impairment that substantially limits one or more major life activity. And this includes hearing, mobility impairments, chronic alcoholism, chronic mental illness, AIDS-related complex, and intellectual disability. I have intellectual disability bolded on this screen because what the law used to say is mental retardation. And President Obama passed something called Rosa's Law. And what that said is that any definition of disability in any regulation in the United States needs to be changed, and the words mental retardation needed to have been removed and replaced with intellectual disability. So just know that if you see anything related to fair housing or related to the definition of a disabled person under the fair housing law, that it is intellectual disability. So we have anyone who has a physical or mental impairment that substantially limits one or more major life activity, as well as anyone who has a record of being disabled. So maybe they receive Social Security disability. They are on record with Social Security that they are disabled, or someone who is regarded as having a disability. So if you can physically see that they're disabled, maybe they come into your office in a wheelchair, they're mobility impaired, so they are regarded as having a disability. So because of the Rehabilitation Act of 1973, we are required to provide reasonable accommodations for those persons that are disabled. And that's why I just gave you those definitions, because they must meet one of those three definitions in order to be eligible for a reasonable accommodation. So again, the people that are considered disabled are individuals with physical or mental impairment that substantially limits one or more major life activities, that they have a record of being disabled, and that they're regarded as having a disability. So you must provide reasonable accommodations if they request them. A request does not have to be in writing. They could walk by you on the property and say something to you, and that could be considered a request, and you need to follow up on it immediately if they are disabled. So what a reasonable accommodation is it's a request to have the person be able to follow the rules, policies, and any other practices at the property that would be afforded to a person without disabilities. So what the whole purpose of having a reasonable accommodation is to ensure that persons with disabilities can enjoy their unit just as someone without a disability would be able to. So if you have a property that receives federal funds, this does affect RD. It affects anything that has any kind of federal funding, any property. So it could be home funds, it could be a HUD insured loan, it could be project-based Section 8. Anything that has federal funds, you are required to pay for, the owner is required to pay for any reasonable modifications to a unit if a person with disabilities that lives in an assisted housing property requests that. So let's say you have a RD property and someone comes in and says that they need grab bars put into their bathroom. If they fall under the definition of disability, you or the owner is actually required to pay for those grab bars to be installed. If you do not have any type of federal funds, then the resident would be responsible to pay for that modification and then return the unit back to the condition it was prior. Most of the housing that we deal with in the affordable housing arena is covered under Section 504. There are some housing operators that are not covered under 504, and so some straight housing credit or tax credit properties that do not receive bonds or home funds or CDBG money, anything like that, they would not be required to follow 504. If you are accommodating a person with disabilities, you have to decide whether or not the request is reasonable. So how do you do that? What the government says is that the request must not be a financial burden, an administrative burden, or alter the nature of the housing being provided. So it is up to you to determine if it is a financial burden or administrative burden, or if it's altering the nature of the housing being provided. So for example, maybe you have someone who is disabled and they are wanting to come and live at your property, and your property is specifically set aside for those individuals that are 62 and older. Well, that by them wanting to live there, they would be asking to substantially alter the nature of the housing being provided. So there is a requirement, a regulatory requirement, that they're 62 and older. Persons with disabilities would not be able to live there unless they were 62 and older, because it would substantially alter the nature of the housing being provided. When it comes to financial burden and administrative burden, this is a little bit more difficult for owners to prove, because you have to be able to show that you have obtained bids, you need to show your financials, you need to fully document that it could be an administrative burden or a financial burden. And if someone did file a complaint, you would have the burden of proof upon you to make sure that you could show that it was a financial burden or administrative burden. One thing that you also do not have to provide a reasonable accommodation on is if that particular reasonable accommodation would pose a threat to either the health or safety of you, your staff, or anyone on the property And you also do not have to allow it if the person is currently using illegal drugs. Now that's kind of difficult to prove. Generally, where we're able to see that someone is currently using illegal drugs would be a criminal background check, that they have recently been arrested or convicted of drug use or drug paraphernalia, that type of thing. The Act does not allow for exclusions of individuals based on fear or speculation of a stereotype. So if a person was coming in and they had, let's say they had AIDS, if there is a stereotype around that it could be a direct threat or health and safety issue, that is actually a stereotype, and that would not come into play here. So you want to make sure that any fears or stereotypes or any feelings that either you or the owner has, that it is not in violation of the law. And determination of that the person, or even if it's an assistive animal, poses a direct threat, there must be an assessment done, and it must be based on reliable objective evidence that the person or the animal poses a direct threat. So you have to have recent history, such as a criminal background check or something that states that the animal is unsafe, that type of thing. I should really have this in bolded letters at the very beginning. Anything that comes to the property related to reasonable accommodation the decision really should not be made at the property level, in my opinion. And I think that you need to seek legal advice. And if your property is under a property management company or an owner that has 15 or more employees, you fall under Section 504. You need to have a 504 coordinator. Those individuals have to go through specific training in order to be a 504 coordinator, and they are really the ones who should help with reasonable accommodation requests. And you'll see in the statistics that I give you in just a moment that disability-related fair housing complaints are the highest and largest amount of complaints that the federal government is seeing. So this really is an area that you need to be very careful, and you need to make sure that you have a lot of training around reasonable accommodation, or that you have people that can help you with that. Owners and management agents cannot require that the applicant or resident provide the request in writing. I had already mentioned that. It's extremely important to know that. You have let's say you have an elderly resident that is walking down the stairs with their daughter, and the daughter says, you know, my mom really cannot navigate these stairs very well. She really should try and move to a first floor. By you hearing that, that is actually a request, and that is something that you need to investigate and you need to document. So you would need to go back to the office and probably send some kind of written documentation to the resident that you're aware that the daughter had made the request, and give them your reasonable accommodation policies, and go ahead and look at providing whatever the request was. And if someone does request a reasonable accommodation, it's extremely important to handle that immediately. There is a lot of case law out there where owners and management agents have been found guilty of not necessarily denying a request, but not responding promptly to the request. So if you are receiving requests for reasonable accommodation, you need to make sure that there is a priority, and that you have good policies and procedures around how quickly you need to respond to those requests. You really should have, or this says must have, written policies around how you're going to handle accommodation. A lot of people put this in their house rules. Some people have separate reasonable accommodation policies, but this is something that you definitely need to have at the site level, not only for you so that you know your operating procedures, but also for residents, and that they understand that they have the right to ask for a reasonable accommodation if they do have a qualifying disability. And then some examples of what might be reasonable would be allowing someone to have an assistive animal. Assistive animal encompasses many different types of animals, and we're actually going to talk about this in a moment, but it is comfort animals, therapy animals, assistive animals, service animals, seeing eye dogs, anything like that. So, and it doesn't just say dogs, it says animals, and we'll talk about, it can be really any kind of animal. Some other things that might be considered a reasonable accommodation would be having trash bins or dumpsters delivered to your property that have actually an opening on the front, so that if someone comes into your property that is mobility impaired, they're able to put the trash into the dumpster without having to lift the lid off. Some other types of things would be assigned dedicated parking spaces, and I get the question all the time when I teach my all-day fair housing. Do we actually have to assign a spot to someone? And the answer is yes, if that is what they request. And I actually have a client that has it's a 202 PRAC property, so it's an elderly property here in Colorado. And the first time I pulled into the property, I kind of just smiled because I looked around and there were reserved for and they didn't actually put the resident's name on it. At one point they did, but what they ended up doing is it says now reserved for, and it has like the tag number or a specific, I don't know the for, but it has a specific like tag and a number that was provided, a parking tag that was provided for the resident. So it says, reserved for tag number 465. And so there are probably 20 assigned parking spaces at this property. So that is one thing that you need to know, that they can ask for assigned, and you do need to accommodate that if they are a person with disabilities. Allowing someone who has a disability to have a live-in aid is also reasonable accommodation, and there are policies around live-in aids. Also, it may be that the person has requested a larger apartment in order to house medical equipment or exercise equipment or that live-in aid. That would also be considered reasonable. So proof of disability. This is where things get a little bit heated, and I know that you all have had this specific situation there in South Dakota as what you can ask and what type of form you should have. So in order to see if something is reasonable and to verify that the person has a disability, the other thing that you would have to verify is that there is a connection or a nexus between the person's disability and what they're requesting. So sometimes their disability may be visually apparent to you and you don't have to verify their disability, but you may need to verify the need of the request so that it is directly related to their disability. So for example, let's say I come into your property and I'm in a wheelchair and I say that I need a seeing eye dog as a reasonable accommodation. Well, I am disabled. You can see that I'm mobility impaired, but let's say I do have perfect vision and I'm saying I need a seeing eye dog. There is no connection with my mobility impairment and my need for a seeing eye dog. So therefore that would not be a reasonable accommodation that would have to be approved. So there again has to be a connection or a nexus between whatever is being asked or requested as far as a reasonable accommodation goes. So the thing to keep in mind, and especially if you have a form that you're sending out to a medical professional or anyone that's verifying a disability, you can ask if the person is disabled, not what their disability is. And I highly recommend that if you do get something back, because this will happen, that shows what their disability is, you want to be very careful to redact the information on the form and put a memo to the file that you redacted the information on the form to comply with the Federal Fair Housing Act. So one thing, as I had mentioned, is you cannot request proof if somebody's disability is obvious. You can request proof to show that there's a connection between the request and the disability, but you cannot ask for proof that someone is disabled. if their disability is readily apparent to you. So if I come into your property in a wheelchair and I say that I'm disabled or I'm mobility impaired, you need to take me at my word. It doesn't matter that you see me out on Saturday night line dancing at the club. If I come in and I'm in a wheelchair, that's proof enough. So again, not putting any social judgments or personal judgments or stereotypes into any kind of decisions. You have to take persons with disabilities if it's readily apparent at face value. You could not verify the disability. The applicant or resident must be disabled to request a live-in aid. So that's one thing to know. In order to have a live-in aid, the person must not be married to that person. The live-in aid is only there to provide services. They would not otherwise be in the unit other to provide those services, and that they're also not responsible for the financial well-being of the person that caring for, nor do they have any right to the unit if the person either passes away or moves out. Depending on the type of housing program you provide at your property, you have to screen that live-in aid. I highly recommend, even if it isn't a requirement under program that you operate, like project-based Section 8 or anything like that, that you are screening live-in aids to make sure that they're not registered sex offenders, that they don't have a criminal background, just so that you and your staff and your residents are protected. So there are certain things that apply to your property as it relates to Americans with Disabilities Act, or the ADA, and that is any kind of public accommodation area. So if you have a leasing office, your leasing office needs to be accessible, and there are certain times where you have to follow the law with ADA. Specifically with service animals, the ADA says that the only qualified service animal is a dog. It's not a potbelly pig, it's not a mini horse, it's not a guinea pig, nothing like that. A service animal is specifically a dog. So if you have a leasing office and you fall under ADA, you may be able to say that, but you're also providing housing, so you're also covered under the Fair Housing Act, which makes that much more broad. So I do have a question. Well, I have two actually. The first one is, what are our responsibilities regarding reporting fraud if it is clear that they're abusing the protections of the law, like line dancing, and they have a wheelchair? So I think that if they are receiving some kind of financial benefit and let's say that they come in and they want the housing because they say that they're disabled, and for some reason you see, let's say it's me, and you see me out line dancing, I think you could always contact the Office of the Inspector General and let them handle it. What you want to be careful of is not getting too involved from the investigative side or reporting side, because you don't want them to be able to come back and file a complaint against you. So if they're breaking the law, then you would obviously want to contact whoever is, whoever's jurisdiction it is to investigate that part of the law. If it's fair housing, you may want to contact HUD, or you can contact HUD's Office of Inspector General. If it is some other law, like maybe they have a handicap parking placard, and it's not theirs, it's their daughter's, and they're using that all of the time, then you would want to contact the local authorities. But I caution you in doing this, because if they do file a complaint and you, depending on where you are in the process, they could say that you're retaliating against them. So I would just be very careful. And when it comes to reasonable accommodations and requests, what I tell people is that the best thing to do is just to take it at face value. And as long as it's not harming someone by allowing the request, that it's probably good just to take it at face value. And I know that that's difficult sometimes, and it's really hard in our industry to see people abuse things that really are not following the rules. But At the end of the day, it could be very costly for you to have to fight a claim. So it's really something that you would want to talk with your attorney about, or your 504 coordinator, to see how you want to proceed. The next question I have is, does HUD disability verification form need to be completed for the person to receive the $400 elderly disabled allowance, even if you can visually tell that they are disabled? That's a fantastic question. No, all you would need to do is document the file that the person meets the definition of disability, and they, if they come in and they are in a wheelchair and they are affirming to you that they're disabled on the application or what have you, then you do not verify anything that is visually apparent to you. If someone comes in and says that they are disabled and their disability is not visually apparent to you, then that is when you can verify the person is actually disabled under the law. So to answer your question, just cut and dry, really clearly, the person can receive the $400 elderly disabled allowance if you can tell, if you look at them and you can see that they are physically or mentally disabled. You would want to make sure, again, that you put something in the file that you were able to it was visually apparent, and that is why you did that, because whoever's looking at your file may not know the situation around it. So the best thing to do is just to document your file.
Say, Heather, this is a question, and this is just one that kind of always nags me about this particular issue, and that is that we're always trained to treat everybody the same. Mm-hmm. And then Fair Housing comes out and says, what, if you can visually determine that there's a disability, you don't have to verify, but everybody else you do. To me, right there, we're treating people differently, and I just have how do I get past that?
That is so true, Vonna. You cut out on me, but I know that the way that HUD looks at that is that it would be imposing a burden onto the person who is apparently disabled. So and another thing along that line too is that HUD says if someone is receiving Social Security disability, and this is just for HUD programs, for programs covered under the HUD handbook, that Social Security, the receipt of Social Security disability is as far as you have to go in verifying it. So their disability may not even be readily apparent to you, but they're on record as having a disability. So you don't have to verify it there. So, excuse me, I think that their whole purpose is to make sure that we're not, that there's no level of harassment is their intent behind that. But I agree with you. It's not necessarily treating people with disabilities exactly the same.
Okay.
I do agree with you there.
Okay. Thank you.
Yeah. Okay. So I'm going to kind of do the Fair Housing Act and the ADA. I gave you the overview there. Just know that if you are providing housing and you have 4 or more units at your property, that you are covered under the Fair Housing Act, and that you must follow everything that we're going to talk about today. If you do have a leasing office, or if you have any kind of area where the public can come in, then you do need to follow ADA, and ADA says that the only animal that qualifies as a service animal is a dog. So that said, if you have residents, though, any of their assistive animals or service animals qualify and could come into your public space because they are housed at your property. So let's just quickly talk about assistive animals, and I'm going to go through this just as an overview. I think we could obviously talk about this for hours, but I'm going to just give you an overview, and again, I'm happy to have discussions or answer specific questions as time allows tomorrow or at the end of the training. But the thing to keep in mind with assistive animals is that assistive animals are not pets. So you have to be very careful how you have conversations with the resident, how you put your rules in writing, anything that comes to you as a reasonable accommodation for an assistive animal, you must use the word animal. You cannot use the word pet. So you cannot use pet rules. You cannot say you need to clean up after your pet, anything like that. An assistive animal is a broad category, and it really covers assistive animals, emotional support animals, therapy animals, companion animals, service animals, and in order for the person to be able to request to have this assistive animal, they need to meet one of the definitions of disability, so physical or mental impairment that substantially limits one or more major life activities, their disability is readily apparent, or they're on record as having a disability. And this animal must be able to provide assistance support that alleviates one or more identified symptoms of the person's disability. So again, I gave you the example, if someone comes in and says, I need a seeing eye dog, and they're not visually impaired, there's no connection there. There's no nexus. And then also, the animal needs to it does not have to be trained or certified to be a assistive animal. So on the ADA side, there are some parameters around that. But from the Fair Housing Act side, as far as an assistive animal goes, you cannot require that the animal be trained. You cannot require that it's a certified assistive animal. I do have a question that says, do you recommend that the property management companies have separate assistive animal and regular pet agreements? Absolutely. Because there are certain things you can require a resident to do for their pet, and there are things that you cannot require that they do for their assistive animal. So I'll give you an example. Let's say you have a pet agreement and it says that the animal cannot be, or the pet cannot be in the unit barking or causing noise. Well, someone has an assistive animal and that animal notifies the resident that they're going to have a seizure or something like that, and they actually do that by barking, that would be putting a rule onto an assistive animal that does not need to be there, because that is part of the service that they provide. So you have to be really careful about doing that. HUD says that assistive animals are not covered under pet rules. So the only thing that you can require of an assistive animal is that they do not pose a threat to you, your staff, or other residents, and that the resident who has the assistive animal clean up after their pet, or has someone that can clean up after their pet, you can require that. And that if that pet causes any damage, you can also charge for any damage that that the assistive animal causes. If the assistive animal causes damage, you can charge the resident for that damage. So those are really the things that are broad that HUD says. There are certain things that local law may come into play, where it would be that they be currently licensed. If your municipality requires that, and they're not, I would still allow the assistive animal. I would just tell the resident and contact the local authorities and say they're in violation of whatever it might be. Like, for example, we're not allowed to have pit bulls in the city and county in which I work in. If I had a property and someone came to me and said, I need to have this assistive animal who's a pit bull, I would say to them, okay, we'll allow your assistive animal, but that is against the law and I'm going to have to notify the authorities. So HUD is really, really, really specific about the rules that you can put around assistive animals. So really it's just cleaning up after them and making sure that they're not a direct threat to you, your staff, or other residents. So I had already mentioned that there has to be a connection between the person's disability and the need for that assistive animal. You cannot charge a deposit. You cannot have a weight, breed, or size limit on any type of assistive animal. So if you allow pets at your property and you only allow pets under 45 pounds, if someone comes in that is disabled and wants a 95-pound Rottweiler, you have to allow that assistive animal as long as they aren't posing a direct threat and even though that particular animal is above your size limit or your breed restrictions. Again, the only time that is permissible to deny an assistive animal is if they are a direct threat or they would cause substantial physical damage to the property or other residents. And at that point, the burden of proof would be on you to be able to prove that they would cause substantial physical damage to the property of others.
Heather, I'm going to take you back again. Your example, the example you gave about not being able to prohibit an assistive animal from barking because that may be their job. What about the assistive animal that just barks all the time and that's really not related to the disability?
That's a great question, Vonna, and I think that just has to be documented. So if, let's say it's a seeing eye dog, and that is the connection to the disability, but that animal is causing a nuisance, then you do have you do have the opportunity to send them a violation letter. Okay. But you want to be really careful about the rules that you put into place, was my point, so that if it is that you could have a rule that no animal on the property can bark and incessantly for long periods of time. That's fine, because if it is a dog that is barking to notify an owner, they're either going to bark for a long period of time if there is a problem, which you would probably Yep. There'd be a welfare check or something like that along those lines. But if it's just an animal misbehaving and barking continuously, that would be infringing on the rights of the other residents, and you could do something about that. But you want to that my point was that I guess I didn't make that very clear, that your rules cannot be extremely restrictive. They need to be enough that it would allow an animal to do what they're supposed to do if they are an assistive animal, but they're not overly restrictive, so that they can provide the function that they're there to provide.
And I thought that was the answer. I just wanted to make sure that people didn't leave today thinking that they could never tell someone who had an assistive animal that they're, so very good. Thank you.
No, that's a great point. Thank you for bringing that up. And like I said, this area gets so complicated, and I know that especially in South Dakota, this has been a huge hot topic the past year, and especially as it relates to verifying the need for these assistive animals, because there is so much abuse, and people have used the law to get around pet policies. Just so you know, I'm very passionate about this subject. I've had multiple conversations with the Fair Housing Office in DC. I've talked to Brian Green several times, and I've even requested that they come up with a national form. They're not willing to do that at this point, but I told them, I said, as housing providers, all of us that are in the affordable housing industry are here to help people, and we're not trying to keep anybody that needs an assistive animal from having an assistive animal. What we are trying to do is stop the unnecessary abuse of this particular topic. So I am an active participant in conversations about this subject quite regularly, and I will continue to do so because I know how difficult your jobs are related to this. So again, the areas where you can deny them is if they pose a direct threat, they would cause substantial damage, the presence of the animal would pose an undue financial or administrative burden to the owner. Again, I think that would be pretty difficult to prove, but if you can do that, then and it falls under this, you have that option. And also the presence of the animal would fundamentally alter the nature of the services provided. Again, this is a kind of a gray area, and it would be difficult for you to prove that. Excuse me. So I had already given you the definition of the Fair Housing Act. I'm going to go through a couple of these slides and move along so that we can finish. Vaughn, I don't know how late you want me to go. I know we're only scheduled for about 10 more minutes, and I really want to get to the case law. So how do you want me to handle that?
Heather, what I would like to do is go ahead and use the full hour and a half that we had. We started about 20 minutes late.
Okay.
If people need to sign off at 11, I'll try and make note of kind of what time we are on this, so they can come back and pick up where they needed to drop off and just watch the rest later. But I don't want you to rush through this. This is good stuff, and so
Okay.
recording it, people can get it later. So
Perfect. Awesome. Thank you.
thank you.
Okay. So just so that you know, just overall for fair housing, what type of housing is covered? So we're moving a little bit away from assistive animals and just going back to the overall topic of fair housing. The types of housing that is covered under the law are any type of rental housing, so 4 units or more, that are not owner occupied. Multifamily rental housing, so any type of apartment community. Condominiums, and we're starting to see a lot of case law around condominium fair housing violations. Cooperatives, mobile home communities are also covered under the law. Retirement communities, nursing homes, and assisted living facilities, which I did not realize. I had a family member who was in a particular nursing home and did some research and realized that nursing homes and assisted living facilities are covered under the fair housing law. Supportive housing and transitional housing, so those types of housing that are provided for those persons that have either a mental disability or individuals who are maybe transitioning from being homeless into having a home. And then also anything that falls under the Stewart v. McKinney Act, specifically single room occupancy units. So those are like often shared space that have individual sleeping and living areas, but they may share a common kitchen or bathroom, that type of thing. So usually they're studio apartments that are considered SROs. I had mentioned owner occupied with 4 or less units. What that means is that if someone has a home and they are renting out part of that home, they have less than 4 units and they're not occupying that particular house. Well, let me go back. If they are occupying that particular house and they have 4 or less units, they do not have to follow the fair housing law unless they are advertising. The minute someone advertises or puts anything out there that the unit is available, then they fall under the law. So for example, let's say I had a duplex and I didn't have a sign out front, I didn't put anything in the newspaper, and I was just, talking to somebody at the grocery store and said, I only want a single white female to live next door to me. Because I live in half of the house, I'm not advertising, I can say who I want to go into the unit next to me. The minute you advertise, though, it doesn't matter if it's owner occupied or less than 4 units, you automatically fall under the law. So that's important to know. Single family homes that are rented without the use of a broker are not covered under the law. If you have more than one single family home, and this is your business, is to rent out single family homes, then you do have to follow the law. But if it's just a single family home that you have and you want to rent it, as long as you don't advertise and you don't use a broker, you do not have to follow the fair housing law. And then anything that is considered public accommodation, such as hotels. The only time that these types of hotels would fall under the fair housing law is if it was an extended stay hotel, like a Residence Inn or something like that, and they were providing housing for more than 30 days, then they do fall under the fair housing law. So just some quick statistics for you. I don't know how clear this is on your screen, but the National Fair Housing Alliance, they put out a housing report every single year, and these statistics are from 2015. HUD is also required to put out a fair housing report. The most current fair housing report we have from HUD is from 2013, but when I do my research, I really rely on either the Fair Housing Assistance Program or the National Fair Housing Alliance to obtain my statistics, because they do update them every year. And these are the types of discrimination cases that have been filed based on protected class. So you can see here that over 50% of the complaints or discrimination processes that have gone into play based on protected classes has been for disability. So over 50% of either the complaints or the cases have been for disability, and the majority of those are related around assistive animals. So this is a big hot topic. Then race comes in a close second, and then familial status third. I really feel that just based on the cases that I've seen recently, I think sex is probably going to take, sex and gender is going to take a higher position on this list as the years come, and I'll share some of those cases with you in just a few minutes. I always provide this statistic because I think this is really important, and this actually comes directly from HUD, and this is information that was provided for the end of fiscal year 2012, so it was provided in 2013, and it shows the different types of HUD housing, so any kind of assistive housing or rental subsidies that HUD provides. And those of you who have project-based Section 8, so a housing assistance payment contract with HUD, the number of units has actually dropped substantially. There's only 998,000 now. It was over 1 million the last couple of years. But you can see here that the race and ethnicity data that is collected for these programs, that the people that are being served by HUD and assistive housing, 52.5% of those individuals are white. So there is a need for affirmatively furthering fair housing and trying to get those individuals who are least likely to apply at our communities to apply. So those individuals who are Alaskan Native or American Indian or Asian, Black, African American, anybody who has multiple races, or Native, Hawaiian, or Pacific Islander. And so this is the reason that we do affirmative fair housing marketing plans, is to make sure that everyone has the opportunity to apply at our communities. This statistic I provide to you because I think it's important to know that most of the people out there that are providing housing are doing a great job, and they're not trying to discriminate. And I think these statistics show that. So these are the complaints that have come in over the last few years. And again, this is HUD data, so it's as old as 2013. But for a 4-year period of time, you can see that of the complaints that came in, over 48% of them were found to have no reasonable cause. And then the complaints were either settled or there were conciliation agreements that were entered into. The ones that are in red are administrative. So what that means is that the cases went in front of an administrative law judge. And then in blue are the cases where HUD or a fair housing agency found reasonable cause for discrimination. So you can see that there are a lot of complaints, but very few of them reasonable cause is found, which is showing that as an industry, as housing providers, whether it be mortgages or multifamily, that we're doing a really good job and that we're not out there trying to discriminate. But that said, if you do have a complaint, it's going to cost you money, and it's going to cost at a minimum of $5,000 for every complaint that you get, just in staff time, copies, response time to whoever the agency is, whether it be the Department of Justice or HUD or a fair housing agency. So there are a lot of complaints, but most of the time there is very little reasonable cause. In 2015, HUD awarded over $40.1 million in grants to fair housing education, outreach, and enforcement, media campaigns, advertisements, and the money that went out in these grants for fair housing actually goes to multiple agencies. So there's state agencies, there are fair housing assistance programs out there. It's not just HUD that does this fair housing outreach and enforcement. And the thing to know from your standpoint is that apartment owners and managers are being fined hundreds of thousands of dollars for violating the Fair Housing Act if they do discriminate. This will show you that there's been a decrease in funding over the last few years. In 2010, there was $42.5 million that HUD gave out in fair housing assistive programs or initiative programs, and because of budgetary constraints over the years, that number has gone down or stayed stagnant. These are some of the actual posters that are out there. These were from the Live Free campaign, which was from a couple of years ago. When I do this live, I show some of the commercials, but if you have time this afternoon, go out and Google these two videos. The first one would be just Google fair housing and accents. And there's a gentleman who, and I know that when you guys did your fair housing class a couple of years ago, when HUD was there, they actually showed the video. But he goes through many different accents and how he's treated based upon those accents. So I think that that's a really good one. And there's another one that basically says, you know, would you rent to me now? And it shows the 7 different protected classes and how people would react to those types of applicants. So there's some really good advertisements out there. If you're up and you can't sleep at night, oftentimes they're on TV late at night as well. This is the most current advertisement in partnership with HUD and the National Fair Housing Alliance, and that you know, the properties need to embrace diversity, and having that diversity actually builds stronger communities. So on the statistics I had showed you under the administrative piece, so sometimes when cases are found to have discrimination, they will go in front of an administrative law judge. If the administrative law judge finds in favor of the complainant that they were discriminated against, these are the monetary penalties, and they're very minimal compared to what actually happens out there. But again, these are, if they go in front of an administrative law judge, the first time could be up to $16,000. Most of the time when there is a case, there are punitive damages and there are compensatory damages. So they're compensating whoever the victim is, and then there are, you know, punishment fees, and then oftentimes attorney's fees, and there's always a training component. So whoever is found guilty has to go through further fair housing training. If there is a violation and the case goes in front of an administrative law judge, and it is the second offense within a 5-year period of time, the fees go up to $42,500. And if there's a third offense within 7 years, I always tell people they need to go find a different job. This clearly isn't the place for them, and they could actually be fined up to $70,000. So it is pretty substantial. There are other cases out there that don't go in front of administrative law judges. Either the Department of Justice will hear them, or HUD attorneys will hear them, or federal judges will hear these cases, and these are the big money cases. This particular case that's on your screen is the largest fair housing award in the last couple of years. What happened was there was a owner of a property in New York City. He hired a manager who was a sex offender. He did not do a background check on this person. The manager provided management services and superintendent services, so he was also doing maintenance at the property, and he was sexually harassing the residents at the property. The residents got together and were talking, as many of our residents do, and they contacted the owner and said, Mr. Owner, that Mr. Manager is sexually harassing us, and the owner did not do anything about it. So, of course, the case goes in front of a judge, and the complainants were awarded over $2 million, and the manager and the owner had to pay civil penalties of $55,000. And obviously, the manager lost his job, and the owner was required to get professional management. When these types of cases happen, generally, if there's a fair housing case, an owner's liability insurance does not cover these types of cases. So their insurance policy doesn't allow for payment of the damages awarded on behalf of the complainants. So that's important to know. And the other thing that's important to know is that everyone at the property is responsible for furthering fair housing and not discriminating. And if it is found that someone at the site level, whether it be a maintenance professional or a leasing consultant or a manager, if they're found liable, they can be personally held liable. So all on-site staff, both maintenance and management, and I provide this training to maintenance personnel. It's a little bit different of a training, but it's extremely important when you're doing that annual fair housing that you are providing fair housing training to your maintenance team as well. And then this also covers all off-site personnel. What I mean by that is an owner or a regional property manager or anyone at the corporate office is covered. The only people that are really covered under the law are board members for properties. So you're responsible for letting your residents and applicants know that you do not discriminate. And how do you do that? The best way to do that is to have a fair housing poster, and you really need to have that fair housing poster in your office. It needs to be readily apparent. So therefore it needs to be in a location that anyone coming into your office can see it. It shouldn't be hidden in the manager's office in the back or in the break room or anything like that. And it all needs to be at a level where everyone can see the poster. So I recommend that people have either two posters or have the poster placed in an area that if someone comes in and they're mobility impaired and in a wheelchair, that they can also read the poster, as well as somebody who, you know, may be able to stand and see it at eye level. So either have two posters, one high, one low, or one in an area where everyone would be able to see it. This is actually, let me go back for a second. This is the area in which you can get certain HUD forms for those individuals who have limited English proficiency, and those individuals who have limited English proficiency are covered under HUD's fair housing law. And you can get different program documents as well as fair housing posters in multiple languages. And when you display your poster, the poster that you have must be 11 by 14. So I always, when I teach this class, I always get questions after the class that says, where did you come up with this? And it's actually written in the law that the fair housing poster must be displayed, it must be readily displayed, and it must be 11 by 14 inches. Now, if you have a fair housing poster in your office that is not 11 by 14, don't take it down. Leave it there and just order one from HUD that is 11 by 14. I tried to order some fair housing posters a couple months ago, and they were on a back order until November. So just know that if you do not have an 11 by 14 and you're ordering one, keep what you have up, because at least it covers you for, you know, showing that you further fair housing and that you have the fair housing poster, but just try and get one that's 11 by 14. In addition, any properties built after March of 1991 that have 4 or more units must contain certain design requirements. So they need to have accessible units at the property. Any units on the first floor must have levered door handles, for example. You must have that 5% for mobility impaired and 2% of your units for those that are visually or hearing impaired. And in addition to that, inside, the design features need to accommodate those individuals, whether it be in the mobility impaired units that you have sinks that you can roll under, that the stoves have the knobs on the front of the stove instead of the back, for anyone who is not able to stand and reach the back of the stove. that type of thing. This is what the fair housing poster looks like if you don't have one. I know that some of you had asked RD questions earlier. If you do have a rural development property, you must also display this and Justice for All poster, and you can obtain that through rural development. So just knowing at minimum you have to have this poster, and then if you have RD, that you also must have this poster. The non-discrimination logo, you need to make sure that you have this on all of your documents, whether it be applications, forms, advertising, your sign, anything that goes out of your office or that is visual to the public. You must have this particular logo, especially if you have a property that is covered by the HUD Handbook 4350.3. So that's the HUD Occupancy Handbook. You have to show this logo. All other properties that are not covered under the HUD Handbook, it is highly recommended that you use this logo. I tell people, I don't know why you wouldn't. This just shows that you understand that you have to provide equal opportunity housing to all individuals. Any property, again, that receives federal dollars is required to use the statement of non-discrimination. And then the other thing I mentioned earlier is that any properties that have or receive funds from HUD, if they have 15 or more employees, they must have a 504 coordinator. And that 504 coordinator does all of the reasonable accommodation requests, and they're responsible for coordinating the compliance under the Rehabilitation Act of 1973. So what is new? These are the things that are affecting properties today. I want to get into Violence Against Women Act first, and just some statistics around this. And I know you're like, I signed up for a fair housing training. Why is Heather talking to me about domestic violence? And the reason is these specific statistics that are on your screen. So 1 in 3 women and 1 in 4 men have been victims of physical violence that has been imposed upon them by an intimate partner. And 1 in 7 women and 1 in 18 men have been stalked by an intimate partner in a lifetime. So you can see here by statistics alone that domestic violence impacts women more than men. And so therefore, because there is certain discrimination that is happening around domestic violence, has a disparate impact on women. And so we're starting to see these domestic violence cases filed under the Fair Housing Law under gender or sex. So again, domestic violence is a gender issue based on statistics alone. Domestic violence is not a protected class because of the disparate impact on women. It becomes part of the Fair Housing Law, and what seems like good management decisions on your part that are made, they really could have unintended effects on domestic violence victims. And your policies could also have really serious impacts on women. If you have very strong, like 3 strikes you're out rules, or any kind of you're evicted if you have the police called to your unit rules, those really put women, or really any domestic violence victim, in a position where they have to make a decision whether or not they're going to call the police or call you or risk losing their housing. So it's extremely important to know that there are really specific things you don't want to do related to domestic violence. So this is the very first fair housing case that we saw, and it was in Oregon. And what happened was that there was a domestic violence victim, and she was physically abused by her husband. The husband was subsequently arrested, and there was a restraining order that was sought, and the resident actually requested to transfer and that her husband be removed from the lease. The landlord informed the victim that they were being evicted due to a zero tolerance policy against violence. So the violence happened on the property, and the landlord was wanting to evict the woman because this violence happened in her unit. The HUD awarded the victim $25,000. I'm sorry, the amount, we don't know the amount that the victim was awarded, but there was $25,000 in attorney's fees that were awarded, plus there was about $7,000 in court costs. And HUD also required that the management agent change their policies as they relate to domestic violence, and they had to go through extensive fair housing training. So we're seeing a lot of properties that have these types of rules, that this no violence rules or 3 strikes, anytime the police are called out to your unit more than 3 times, you're evicted. Those kinds of rules are really impacting, and we're starting to see a lot of fair housing cases around them. The 2 most current cases are very similar. The first one was just settled in 2013, and what happened was it was a municipality. So this happened in Norristown, Pennsylvania, and the municipality had a ordinance in place that said that if the police were called out to a unit out of a multifamily property for any kind of disorderly behavior or violence, that the owner was required to provide the resident with a notice to vacate, and if they did not, the owner would be subject to fines and possibly losing their rental license. So there was a situation that happened, and the resident was stabbed repeatedly and actually had to be flown off of the property. But Flight for Life had to come and take the resident from the property because she was in such horrible condition from this violence. And the owner was told that they had to evict this resident, and the owner said, no, this is a great resident. She's paid her rent on time. She's a victim of this assault, and I'm not going to evict her. And so then the town of Norristown, Pennsylvania, decided they were going to go after the owner. So the owner and the resident worked with the ACLU and filed a complaint against Norristown, Pennsylvania. Norristown specifically to this day opposes the complaint, and they said that they felt that both of the ordinances they had in place were gender neutral, and that it wasn't against women or men, that anybody would have to go. The HUD didn't agree with that. So what ended up happening is Norristown, Pennsylvania entered into a conciliation agreement, and they agreed to repeal both of the ordinances, and they're under a conciliation agreement for 2 years. They paid $495,000 to the victim that was airlifted off the property and was told that they had to vacate. The city employees had to go through extensive fair housing training. This included the city administrator, the city council members, the director of code enforcement, the chief of police, any person who had any type of interaction with victims of domestic violence or abuse had to go through this fair housing training. And one of the other stipulations in the agreement was that they would continue to receive annual fair housing training. And then they also had to develop a community education and outreach program. They had to publicize that program, and they had to pay for the particular program. So it was pretty costly for the town of Norristown, Pennsylvania. The other most common one actually happened on the East Coast as well. Same type of situation. A resident was abused and was told that they had to leave. And when they went to go find additional housing, they were denied that housing because of poor rental history, because of the domestic violence on the property. And so that person was also awarded, I think it was almost $1 million. It was a little under $1 million based on the fact that she was being evicted and could not find future housing. So those are the 2 biggest cases we have right now. There was another case that happened here in Colorado several years ago. It was in 2003, actually. The resident was stabbed, raped, and beaten by her boyfriend in a project-based Section 8 unit. And because she feared for her safety and the perpetrator was actually on the run. She had asked the landlord to transfer her until her ex was caught. And the manager refused to transfer her, said it was not part of their transfer policies. And this happened to be it's not a scattered site, but it's two separate buildings in two separate locations under one HAP contract. And this particular person had to go into hiding with her family until her ex was caught. And when she went back, they would not let her move back into the unit. So she settled the case with the management agent for over $60,000. The management agent had to change their policies. And then this is a very similar one where the resident had someone stalking them. This didn't involve domestic violence or abuse, but it was more stalking, and the perpetrator actually damaged the property. The resident had to pay for those damages, and so she actually sought monetary relief from the property owner because of the damages, and then the property had to actually reimburse her for those damages that she paid for, and had to change their policies. So again, how does this apply to you in your everyday? How do you comply to make sure that you're following both the VAWA regulations and the property regulations? And that would be that you want to make sure that you do not give any domestic violence victims notices to vacate your property solely based on criminal activity. The thing to keep in mind here too is that the Violence Against Women Act, the Reauthorization Act, covers almost all types of housing that we deal with in the affordable housing world. Project-based Section 8, it covers tax credit or housing credit programs, it covers home, it covers 202 PRACs, it covers almost all affordable housing. We're waiting to get guidance from the different agencies on how to implement this Reauthorization Act, but you still want to make sure that you're not evicting people just simply because they're victims. If I always get the question, well, what if there's other things going on? So, if the police show up and, there are crack pipes everywhere and there's drugs being done in the unit, obviously you evict on drugs. You're not evicting because of the domestic violence. You're evicting because of some other lease violation. That's fine, but just solely because they're a victim of domestic violence, it'll get you into trouble if you're evicting for that. You need to make sure that you have policies that state how you're going to bifurcate the lease for those people that are the perpetrators, and how you're going to protect the person that's staying in the unit. You need to have lock change rules. You need to have rules around how you're going to handle protection orders, and you're also going to need to have rules on how you're going to protect their identity, so that any individual coming in trying to get information about them, that their information is not released without their permission. So just some final thoughts on domestic violence. I'm going to go into familial status cases with you really quick too, before we finish up here. But final thoughts on domestic violence: it's not a lease violation, and that you want to make sure you're not imposing those zero tolerance policies or those 3 strikes you're out policies. And if you do have questions, that you send those questions or send the residents to the National Domestic Violence Hotline, and that you are providing a safe haven for them. Just quickly, I'm going to give you 2 specific case laws related to familial status. We talked about that quite a bit at the beginning. There was a case here in Colorado in Centennial and I'm seeing this all over the country, and if you happen to have these types of rules in place, it's something that you want to take a very close look at with your attorney, because we're seeing huge amounts of cases related to this now. And what happened was this particular property published a notice in their monthly newsletter that went out to all of the residents, and what that notice said is that all children must be supervised by an adult at all times while playing outside, and that no sports activities, skateboarding, rollerblading, or general extracurricular activities are to take place in the community. And if they were to see anyone that were violating those policies, or being a part of any of those activities, that would be sent home immediately, or if they saw any children outside, that they would be sent home immediately. So what the problem is here is that because the rule specifically called out children, that is a violation under the familial status portion of the law. So in this particular case, the federal government found against the property, and they said that in order for them to resolve the allegations of discrimination, they had to enter into a conciliation agreement, and that part of that agreement said that the managers and the owner were required to design and build a play area which had accessible features for persons with disabilities. They also had to undergo fair housing training with a certified fair housing trainer, and the property management company was required to amend their policies and not have anything in their policies that stated that children had to be accompanied. This is my favorite case. This is a case that happened in Napa, California. Actually, I think I'm going to give you three cases. There's a Napa, California case and a Kansas case. But in this particular case, same thing. The manager said that children were not allowed to be outside, and if he saw the children outside, he would curse at them and require that they go into his office and sit on the floor, and then he would berate them, and then he would also tell them that they had to clean the toilets in the leasing office and pick up trash around the property as punishment for being outside. If they refused to do this, he threatened them by telling them that them and their families would be evicted. And so obviously HUD found a problem with this, and during their investigation they also found that there were very restrictive rules barring the children from using the swimming pool during particular hours. So in the conciliation agreement that happened, the owners were required to pay the Fair Housing Assistance Program of Napa Valley a little over $3,000. They were also required to waive 4 months rent to 5 of the 7 families that complained, and that was a total of $19,000. 2 families actually moved out of the property, and they were awarded $7,000. And the owner obviously had to change their policies about the usage of the pool by children, and they also had to obtain fair housing training. This last case, similar type of thing, that anyone under the age of 18 was not allowed to use any of the common areas in the property, and they really could not be outside without being supervised by an adult, and that they could not use bicycles, skateboards, scooters, or anything of that type on the property. In this particular case, there was a retaliation piece, and what happened was when the resident refused to abide by these policies, management said that they were not going to renew their lease in retaliation. And so the agreement that was entered into said that the owner and the agents had to pay $170,000 to settle the lawsuit, and $60,000 went to the family who initially originated the complaint, and they also had to pay civil penalties. So those punitive damages to the federal government, and that they would enter into fair housing training. So you can see that there's always that fair housing training component. So what does HUD say about these particular recent cases, especially around fair housing? The Assistant Secretary of HUD, Gustavo Velasquez, says that fair housing and equal opportunity is extremely important. Overly restrictive housing policies for families with children are illegal, and that it prevents them from fully enjoying a place that they can call home. And HUD will continue to work with the Department of Justice and take action against any property owner or landlord whose policies violate the Fair Housing Act. So you may be sitting there thinking, we have policies that state children cannot be out on the property without being under the adult supervision, or children cannot play soccer on the grass. My recommendation to you is to talk with your legal counsel and also change your policies so that they state that no one can do a certain thing. Like Vaughn and I were talking about beginning about snowboarders. Nobody can snowboard on the property. Nobody can skateboard on the property, so that it is not specifically singling out children or families with children. Again, this is a legal issue, so you definitely want to work with your property management attorney. So make sure that you are using caution in implementing policies and that you're not involving children in those policies. If you do have swimming pools or exercise rooms and your insurance, would be taken away or increased if certain, children were using the either like the exercise room or the pool, then that's when you need to talk with the Office of Fair Housing and find out how you need to word your policy so that you're compliant. And really, like for the pool, if you don't have a lifeguard on duty, you really need to say no one should swim alone. Children should not use the pool without adult supervision, because we all know adults that need adult supervision. So just make sure that you're not calling out children in specific. You also want to make sure that you are not being overly restrictive, and also that you are not punishing anyone who violates the rules with manual labor. So there is a quick question on this about does HUD provide any guidance on what is appropriate age for minors to be unsupervised? We've observed toddlers in diapers wandering alone outside. Absolutely, and that is absolutely not okay. I would call the police in that case. Again, it removes you from the situation. Obviously, that is against the law, that they, should not have their children running around outside. I would definitely call the authorities on that. But HUD guidance on this is that you cannot specifically call out children being unsupervised. So I would definitely talk with your attorney, because that will get you in trouble if you have anything in your policies that says minors need to be supervised. Fauna?
Did you see the other question that was right before that one?
I didn't. It says tenant keeps allowing an abuser into the apartment home and the abuser is not on the lease or the resident. Of the resident. Can you evict her because she won't stop letting him come back? I actually get this question every single time that I do this training. You cannot, and this is very common. If a resident exercises their right, especially under VAWA. So they come to you, they fill out the certification, they say that they've been a victim of domestic violence, they've had the person removed from the property. They're covered under VAWA. If that person comes back, which they will, if that person comes back and there is another situation, it starts all over again. So where it may be very frustrating from a management standpoint, the thing to know about domestic violence is that there is a cycle, and that very rarely do victims of domestic violence ever not allow the person to ever come back. Almost always they allow them to come back, and they come back repeatedly. Now, if that person is violating let's say it's an unauthorized occupant, you handle it as an unauthorized occupant. It cannot be related at all to the domestic violence. So you need to have unauthorized occupant rules in place and follow those rules and give lease violations on that particular behavior, not that it's related to domestic violence. If that person keeps coming back to the property and is causing harm to the property or damage or perpetrating violent acts on the property, you can have that particular person trespass on property. That's what HUD says to do, is to trespass that person. But the person that is the victim is protected under the law. So just know that they have the right to, and especially if you're at a HUD property and you fall under the current VAWA requirements, they have the right to be there, and they have the right to be safe under the law, and that they are going to let that person come back. And so that if that person is violating any other rules that's coming back, that you are specifically giving notice based on the behavior that is the lease violation, not that it is that they're letting them come back.
Heather,
very difficult as a manager.
I see you have a few slides left. I think we should try and wrap this up.
Okay.
Just quickly. Thank you. Did you want to finish anything? I didn't mean to cut you.
No, that's good. And these are really quick because these have been around for almost 4 years. The sexual orientation and gender identity rule, that if you have any kind of HUD program that participates under the 4350.3, you cannot deny someone housing or evict someone simply because of their marital status, their sexual orientation, their gender identity. It specifically provides protections to those individuals who are lesbian, gay, bisexual, and transgender. So this is a housing notice. It was put out in March of 2012, and it's actually an executive order from the President of the United States to HUD. So that is all that I have for those two. And again, thank you for the time that you gave us. I know we went a little bit over, and I just want to make sure that you understand that you can contact me tomorrow with any types of questions, and we will do a question and answer FAQ and have that put up on SDHDA's website. So Vanna, I'll turn it back over to you.
Thank you, Heather, and thank you so much. You did a great job, particularly after all the issues that we started. I appreciate everybody that stayed with us through the webinar. As you can tell, it was really good information. The recording will be out there hopefully later this afternoon, if not today, for sure tomorrow. The handouts are already there. If you didn't find those beforehand, they'll be there. I will post links to those things, or I'll send out an email to all of you with the handouts, the link to the recording. And then I also wanted to let everyone know, if you didn't notice, we actually did this webinar a month later than we normally would on our 3-month schedule. October just gets too busy. There's just so much training and everything going on, particularly including our housing conference. So we bumped this one to November. I'm thinking that I like the idea of just keeping on that schedule going forward. So look for our next webinar in February. We'll go February, May, August, November now. If anybody has any real issues with that, let me know. Otherwise, if you have topics for future webinars, please let me know. Otherwise, I will let you go. Thank you so much. We really appreciate you all staying with us. Have a great day.
Have a great day. Thank you.
Thank you, Heather. Really appreciate it.
Sure. Bye-bye.
Yep, bye-bye.